Hearing in appeal, Telereal, Trillium and Hewitt.
Oh, I'm sorry we've been delayed a few minutes by a technical hitch. Miss McCarthy.
Thank you. Good morning, my lords, my lady. I appear with my learned friend, Mr. Hugh Flanagan, for the Valuation Officer, and Mr. Richard Glover, QC, and Mr. Kane Ormondroyd appear for the respondent, Telereal Trillium. My lord, I'll take our written case as read. There is a substantial volume of material, so if I don't go back to any of the more minor points, it shouldn't be assumed that we've conceded any of them. In terms of the order of my submissions, I intend to make my submissions in the following order. First, I'll address your lordship about what we say the case is actually about, and what it isn't about. What is the true issue in the appeal before the court, because there's been some real debate about that generated by my learned friend's written case. Secondly, I'll address the court on the upper tribunal's actual decision and reasoning, and make our submissions on why we say the upper tribunal was right, and then I will go on to address the Court of Appeal's decision and why we say it was wrong to overturn the upper tribunal. And so just by way of overview, if I may summarise our position on these 3 points, we say this case is about the effect of rateable value, the effect on rateable value of oversupply or market saturation. This case is not at all about the effect of obsolescence or the end of economic life on rateable value. In other words, we say that this case is an illustration of the parade of identical shops, one of which remains empty. That is what this case is about, and whether it is right in that scenario to apply similar rateable values to all 5, if we're assuming 5 shops in the parade. It's clear, and I'll show your lordship, that this was how the case was decided and addressed below. The upper tribunal decided that just because there happened to be 1 fewer actual prospective tenant in the market at the date of valuation, so call it 24 potential tenants for 25 properties, that in and of itself did not justify a substantially lesser value being applied to the empty property being Mexford House. So the upper tribunal determined the rateable value at the figure of 370, which the parties agreed was the right figure in the event that this notion of general demand was relevant to valuation. And the upper tribunal rejected the ratepayer's proposition that the only possible rateable value was nil in a scenario where you've got, as we've termed it, no actual prospective tenant on the valuation date itself. Now, in contrast, the Court of Appeal determined that the inevitable consequence of this oversupply, this market saturation, a phrase that crops up, I think, 4 times in the discussion, was nominal rateable value for the hereditament, simply because, by accident and by bad luck, it found itself without an actual prospective tenant on the valuation date. My final point, just by way of introduction, if I could ask your lordship please to turn to the statutory question. So this is Authorities 1, Tab 1, MS 500. I think for my purposes, paragraph 2.1 of Schedule 6 of the 1988 Act is the only statutory provision I intend to go to. The rateable value of...
Sorry, which page are we on?
I'm sorry, MS 500.
Thank you.
So this is the 1988 Act, Schedule 6, Para 2.1. The rateable value of a non-domestic hereditament shall be taken to be an amount equal to the rent at which it is estimated the hereditament might reasonably be expected to let from year to year on the following three assumptions. We know that we are to value the hereditament by reference to the 1st of April 2008 and take market demand as it was on that date. Just for your lordship's note, over the page, you'll see the matters referred to in paragraph 2.7. These are matters which are to be taken into consideration when the valuation is done, as they existed on the 1st of April 2010. So just taking 7A as an example, matters affecting the physical state or physical enjoyment of the hereditament. You look at what Mexford House looked like in its physical state on the 1st of April 2010, and if you like, carry that physical state back to the 1st of April 2008 and ask what would the market value have been on the 1st of April 2008, bearing in mind the 2010 physical state, if that makes sense. So you can see that what we're being asked for is a purely hypothetical valuation as at 1st of April 08 of a property that wasn't necessarily in that state on that date. The statute, para 2.1...
Sorry, the items in 7 are brought in by subsection 5, is that right?
Yes, my lord, that's correct.
And what about E, 7E? What are you taking into account about the occupation of other premises?
So 7E, our position is set out in our written case, and just for your note, that is paragraphs 83 to 91, which is MS 80. But the headline point is that 7E is not looking at market demand in the intangible sense of supply and demand. Rather, what it's considering is the physical use or occupation of premises. So, for example, if you've got a shop that's been boarded up, the fact that it's boarded up is what you're taking into account, that physical use or occupation.
Or if you're located next to a pub or a tannery or something of that kind.
And that has an impact on the value of your hereditament. Exactly right, my lord. So, whilst we're on 2.1, your lordship can see the statute poses a question of value, and it's clear from the authorities that that is a question of fact. And in those circumstances, the Court of Appeal can only intervene essentially if the upper tribunal has included something in its consideration that it shouldn't have, or if it's excluded a relevant consideration. And just for your lordship's note, we don't need to turn it up, the case that talks about those principles in the bundle is Mersey Docks and Birkenhead. It's authorities 1 tab 9, and then the MS numbers are 717 to 718, 721 and 722. And it says in terms what I've just summarised. Now, the relevance of that proposition here is we say that it's clear from the face of the upper tribunal's decision that the upper tribunal took into account the absence of an actual prospective tenant. So it can't be argued that the upper tribunal ignored that fact. The upper tribunal also took into consideration its view of the effect that general demand had at that date on value. Now, weighing up these factors is, of course, not something that the Court of Appeal should interfere with, so the Court of Appeal can only intervene if it says that the upper tribunal was wrong in law to take account of general demand. In other words, bearing in mind the joint position paper that we'll go to in due course, the upper tribunal can only intervene if the absence of an actual potential tenant on the AVD itself necessarily resulted in a nil rateable value without more. Because if you're allowed to look more widely at general demand, for example, that's exactly what the upper tribunal did, then it becomes an evaluative exercise with which the Court of Appeal shouldn't have interfered. Now, that was by way of introduction. Moving on to the first part of my submissions, what we say this case is actually about and what it isn't about. It's critical to begin here, because your Lordship will have seen that Telereal say in their written case, in effect, that we are shut out from running the arguments that appear in our case because of how they say the proceedings developed below, and we, of course, don't accept that. So they take issue with how the evidence and arguments developed below, how the joint position paper should be interpreted, what the upper tribunal actually decided, and therefore what the issue was before the Court of Appeal, and how all that shapes what the issue is before your Lordship now. They also introduce for the first time a new concept of economic obsolescence as a third class of obsolescence, which has never been referred to in terms below, not even by their own expert or in their own submissions. They quibble with our usage of the phrase end of economic life in an attempt to revive an argument before your Lordships that this is an end of economic life case. But these matters are entirely unsupported by the upper tribunal's actual findings, and also by the points that they raised in cross-examination of our expert prior to the joint position paper being agreed. As I will show your Lordship, had they wanted to extract a concession about obsolescence, it would have had to have been included in that joint position paper as an express concession. And I'll also explain in due course why, in fact, the terms of the joint position paper, including in particular paragraph 5b, actually preclude them from running that argument now. And in essence, it is because Telereal agreed that Mexford House was comparable with another property called Hesketh House. Hesketh House, on their own evidence, was not obsolete, and that led to a rateable value of 370 if taking into account Hesketh House was permissible. Now, in that scenario, if the two are properly comparable, and Hesketh House isn't obsolete, then necessarily nor can Mexford House, otherwise they're not comparable. If in fact they're both comparable, but in fact they're both obsolete, then one wouldn't expect on any view to have this agreed rateable value of 370, because our case throughout has been obsolescence equates to a rateable value of 0. And if that had been the way that the argument had played out, then we would have had a very different decision from the upper tribunal based on facts and evidence concerned with end of economic life and obsolescence, and that would primarily have been a decision on fact, and none of this general demand would be relevant to that decision. But that isn't what the upper tribunal decided.
Yes, I mean, at the end of the day, we're going to have to be clear ourselves as to whether what we're being asked to do is effectively make a one-off decision based on the an interpretation of the JPP, or on the other hand, make a decision which is going to be of general importance about the law of valuation for rating.
And what I will explain in due course is that, in effect, is what the JPP encapsulates. So I appreciate that the Court of Appeal made its remark that, well, this is quite an unusual case, but that was contrary to the upper tribunal's position that this sort of thing is of general importance, And of course, the upper tribunal was the fact-finding tribunal that heard the evidence, and that was the tribunal before which the joint position paper was agreed. So they will have been fully cognizant of the context of that agreement.
Yes, I mean, I was wondering to what extent that sort of you take account of the fact that the upper tribunal was fully aware of the background of the joint position paper and obviously were content that it reflected what they thought were the relevant issues.
And my lord, that is exactly what we say is key. So if I may take your lordship through some of the background papers to the upper tribunal, I intend to do this very efficiently. I don't intend to go through all the papers in detail, just to pick up some of the key points so that you can see exactly how the issue took shape and why it is we say we're right on what this case is all about. Because it seems to me that that is the submission that anchors everything else we say.
You'll be coming back to the law on valuation.
I will in due course, my lord, but I think it's important to understand precisely what the question is before we move on to look at how the law applies to the right question, as opposed to what we say, applying it to the wrong question, which is what Telereal is seeking to do. If I could ask your lordship please to turn to the appendix in the core volume. The first document is our statement of case before the upper tribunal, and that is appendix page 205, MS 342.
342.
MS 342. So 2 paragraphs to note in this document. This was our statement of case before the upper tribunal. At the last sentence of paragraph 4 at the bottom of MS 342, our case was the valuation tribunal wrongly treated the subject property as obsolete and of nominal value. I should say I'm not going to take your lordship to the VT decision because the upper tribunal was a complete rehearing. Over the page then, paragraph 9, is where we set out how the issue took shape. Essentially, just because a property is unoccupied, it does not just justify a lesser value than that applicable to similar occupied properties. There are a number of occupied comparable properties in the locality, and that showed that there was market demand. Now, if I may just note at this stage, the words, these comparables establish that there was market demand for the appeal property. So that's halfway down that paragraph. This is shorthand, and I'll show you in due course why it is I say that, for market demand for property of the type, size, age, etc. of the appeal property. Now, no one was ever suggesting that, for example, the NHS who occupied Hesketh House was in the market to move out of Hesketh House and wanted Mexford House. That was never the way that the case was put. It is expressed this way in this shorthand because essentially it's well understood that the rentals method of valuation works by analysing the level of demand in the market for property with comparable features, and that appears in some of the case law, and I'll take your lordship to that in due course.
And presumably it was a straightforward valuation on the comparative principle.
Exactly right. So that is how we saw this case. Turning then to the ratepayer's statement of case before the upper tribunal, is it more convenient, since the MS numbers are printed, if I just refer to those?
Yes.
MS 349 is where the ratepayer's statement of case begins. So 4 paragraphs that I need to take your lordship to. First of all, the last sentence in paragraph 4, that belief is noted, it's not shared by the respondent. That's a cross-reference back to our paragraph 4, which included the reference to obsolescence. So, Telereal disputes the contention that Mexford House is not obsolete. Moving forward to paragraphs 15 and 16, please, MS 352. What these paragraphs are seeking to do is they're seeking to argue that none of the actual public sector occupiers of other comparable properties actually wanted Mexford House because their needs were met. We don't disagree. Moving forward, paragraph 18, please, MS 353, 4 lines from the top. Supply much exceeded demand. Telereal also make the point that there are no true comparables since other offices were of better quality in terms of specification and location. So what they're essentially saying here is Mexford House is the worst.
Sorry, paragraph 18?
Paragraph 18.
Thank you.
Bottom sentence.
Thank you.
Last sentence. So their case is you can't rely on comparables. Mexford House is essentially the worst. You can see then from paragraph 21, MS 354, that in the circumstances, Telereal contends that the rateable value of £1 is appropriate, and at the hearing they intend to refer to the comparable assessments in the schedule. That's MS 355. This is a schedule of comparable hereditaments where the assessments or rateable values from an appeal were all nil. Now, in due course, you'll see that we say, well, they're in Devon, Avon, Norwich, they're not in the locality, they're not properly comparable, so these are irrelevant. And that, in due course, was not pursued further by Telereal. Now, our reply is at MS 356. Your Lordship will see from paragraph 3 that we seek to align a nil rateable value with obsolescence, and our point is Mexford House isn't obsolete. Paragraph 3b over the page, MS 357, is important, and it sets out our case clearly. Because there were comparable properties which were occupied, it follows that there was general demand for the mode and category of occupation in the location. So that, in essence, is our point. Mere vacancy isn't sufficient to achieve nil rateable value. Where there's general demand of occupied property, that isn't materially different.
This one itself, wasn't it occupied at the AVD?
It was.
Yeah.
And at that point, and this brings me on to paragraph 4, at the AVD, however, the DWP and HMRC had given notice to vacate, so they'd announced their intention that they didn't want the property anymore. This is key, 4 lines down. However, there's no evidence to suggest that the reason for this was due to the appeal hereditament no longer being capable of rateable occupation. In essence, we'll see they handed the property back because their needs changed, not because of any intrinsic deficiency in the hereditament itself. Paragraph 6 is key because here we make it clear that we use the phrase there was demand for the appeal hereditament as shorthand when we're talking about general demand for the mode and category of occupation. So that was the point that I was making earlier.
So which paragraph was that?
Paragraph 6, my lord. We are not referring to specific demand for Mexford House itself. We also clarify what we mean by obsolete, resulting in nil rateable value, which is when a property is materially different to all other occupied properties and remains vacant because of lack of demand.
It's quite tricky, this, isn't it? Because obviously the rateable value of a property is going to reflect the balance of supply and demand on the hypothesis that the statute requires, which is going to the rateable value of a particular property is going to reflect supply and demand for that property amongst others.
My Lord, I think this is the point that we say is at the heart of this. So if I can develop this a little by way of example, when Hesketh House is valued as at the AVD, it is valued by reference to supply and demand in the market, and that will take into account the fact that Mexford House is standing there, not necessarily vacant, but with the present tenants having served notice to move out. So Mexford's House vacant situation, if I can call it that, is taken into account in Hesketh's House valuation. 2 points arise from this. The first one is, why are we then to shut our eyes to Hesketh House's occupancy when we come to value Mexford House, because all of a sudden we're not valuing in the same way? And the second point that flows from it, when the valuers estimated rateable value of Hesketh House at £59 per square metre, that was on the basis of, if I can use the shorthand, 24 out of 25 balance between demand and supply. So that figure of 59 already encapsulates the fact of Mexford House's vacancy. We are trying to apply that figure of 59 to Mexford House, and we're told we can't do so because that doesn't reflect the fact that no one wants Mexford House. But of course it does. If there had been, say, 10 other vacant properties, when valuing Mexford House, the valuer may well not have come to 59, he may have come to 48, reflecting the fact of those 10 vacancies in that figure. So we say it's perverse that when you value an occupied property, you're allowed to look at the totality of market demand and take that into account in the figure that you reach. But when conversely, you're looking at the vacant property, you're not allowed to look at any of these features at all. And we say that breaches, amongst other things, the fundamental principle of uniformity, and I'll come on to look at that in more detail when I go through the law. You have to value like with like, and you certainly can't start valuing some offices one way and other offices in another way, because all of a sudden you undermine the entire foundation of the list, which is not so much to arrive at true value, but it's to arrive at value which is applicable across the board, if I can say that. So correct by reference to every other hereditament.
The issue of whether an unoccupied rate is subject to rating at all is a different issue covered by a different legislation, presumably, is it?
Yes, exactly.
What is the relevant statute?
Well, there are... what I can do, I don't think it's in the bundle, but I can get the provisions over the short adjournment. But there are provisions that give some reduction for vacant rates, for example.
But I mean, that sort of changed over time and is obviously a political issue. But it's important when looking at this issue to remember what the question of occupation or non-occupation is a different issue in rating terms.
Yes. And the question here is not, is Mexford House rateable? I think it's not disputed that it absolutely is rateable. It's what is the value, which is a pure valuation question. Why is it that the Court of Appeal is shutting its eyes to evidence of the market in relation to Mexford House? It's not a black and white issue. There's no one right answer. It's an evaluative weighing up of all the evidence, which is exactly what the upper tribunal did, and the Court of Appeal said the upper tribunal was wrong to do.
Yes. I'm just thinking this through in my own mind. You're saying that the valuation officer will have information about the actual rents being paid for the occupied offices in the locality.
Yes.
And he'll also know that there are a certain number of offices that are unoccupied in the locality. And the rent being paid for ones that are occupied is going to reflect the fact that there is a greater supply than there is demand.
Yes, that's absolutely right.
Yeah.
And other factors when arriving at rateable value. So as it happens, the actual rent being paid for Hesketh House was, I think, something in the 70s, but the rateable value was taken as being £59 per square metre. And that may well be, now this is pure speculation on my part because there was no evidence, we don't know, but that may well be because, for example, there were downward-only rent reviews, so perhaps the actual rent was higher than the market rent would have been.
Yes.
But all that is taken into account in arriving at the figure of 59.
Yes. And sorry. No, please.
It is the mechanism by which the value of the rent
Yes, my lord, I think if I understand your question correctly, that is correct. So if one was to take, say, Hesketh House as vacant and to let, it may be that there is some reason why in the real world rent of 70 per square metre is being paid. But when taking it vacant and to let and ignoring any circumstance that's accidental, so any circumstance that's personal to the contract, it may be that the valuer has determined that the figure of 59 is in fact correct. Yes. My lord, that's absolutely correct. And we say that that necessarily must be just as true when it comes to value Mexford House. Because you certainly can't have some information taken into account for Hesketh House and swept under the carpet for Mexford House. And that would drive down, depending on all the circumstances, of course, that would potentially drive down the market rent, the rateable value of Hesketh House.
Yeah.
just about to be occupied by a willing tenant on a negotiation with a willing landlord.
Because the statute requires the valuation to take place on a vacant and to let basis. Exactly right.
Do we assume a willing tenant and a willing landlord? In the Land Compensation Act, it actually says in the Act, you assume a willing purchaser.
So the case law tells us that we do here, and that's two cases. First of all, that's IRC in grey, and I appreciate, of course, that's an inheritance tax case. But then Smith and Churchwardens, which I'll show your lordship in due course.
We'll come to it in due course. Thank you.
The willing tenant doesn't do anything about whether he's prepared to pay any rent. Tenant at a nominal rent.
Well, and for example, when a property is obsolete or at the end of its economic life, that may well be the outcome, yes. But whereas here, we still have property that is still serviceable, maybe if I can put it this way, as at the AVD, if we're right about the issue and the context, it's not obsolete, it's not at the end of its economic life. As at the AVD, the hypothetical landlord would have a reasonable presumption that there might be a tenant willing to take up the property in due course. Now, what we're not doing is gazing into our crystal ball and looking down the line at the future, but what we're doing is looking at that possibility as at today's date, as at the AVD. If a property has been vacant for, say, 5 years, 10 years, the hypothetical landlord will think, well, there isn't a tenant round the corner, this is looking far less likely. But in the circumstances of this case, where HMRC and DWP have just served notice, not because of any inherent flaw in the property, and they were paying substantial actual rent of £417,000 per year, and the hypothetical landlord of Mexford House looks out and sees Hesketh House and all these other comparable properties occupied at substantial rents, in that scenario, part of his real life today consideration is necessarily going to be the possibility of a tenant just round the corner. And that is going to factor into why today he's not willing to let the property for £1, because that in no sense is sensible when you look at the body of evidence. Now, as I say, 10 years later, assume a scenario where Mexford House has remained totally unlet, Hesketh House is now vacant or has been refurbished or whatever the case may be, there are no more comparables. Of course, the hypothetical landlord in that case is going to have totally different considerations. But we're not valuing at that point in time, we're valuing it as at the 1st of April 2008.
How does it come into this real-world scenario that the landlord may ask his advisor, what's the score? And the advisor may say, this is only a public sector type property and I can't see any public sector organisations on the horizon because they're all accommodated. How does that come into the...
So, my lady, that would be a pure matter of evidence. And we would say that that essentially was compromised in a world in which paragraph 5b of the joint position paper, which we'll come on to see, was agreed. Because that scenario does not tally with agreeing that Mexford House is truly comparable with other properties that aren't obsolete and are fetching substantial rents.
But supposing
Yes.
that was the advice that he received, then
that would be a matter of the evidence for the upper tribunal to weigh up, and that equally may drive down rents, depending on the quality of that evidence.
My lady's question is, I think, premised on the assumption that on the AVD, the hypothetical tenant and hypothetical landlord can look around them and see that Hesketh House is occupied and other properties occupied and so forth. I'm just wondering, is that right? Or on the AVD, do you assume that the entire, that all properties are available for let?
So I think the correct position is when you come to value the property in question, it's valued vacant and to let. But you absolutely take into account the fact that you're in a market where 24 out of 25 properties are occupied, so there is a small amount of oversupply.
Do you? I mean, is that the right way to put it? That you take account of the fact that 24 out of 25 properties are occupied? I wonder, is that right? Or do you take account of the fact that there are 25 properties and the level of demand in the market is only sufficient for 24 of them to be tenanted?
Well, we would say that that amounts to essentially the same consideration, but on neither footing do you result in a nil rateable value.
Well, it may be at the heart of this issue about the effect of the JPP. I mean, effectively, do you assume that level of demand is such that there is a limited level of demand and that demand has in fact already been exhausted by the lettings of Hesketh House and so forth, or not?
So I think the question, my lord, is was there evidence, or sorry, more to the point, did the upper tribunal make a finding that that demand had been permanently exhausted? And we say no, because if temporarily there's no reason why a new tenant for Mexford House won't be found, then that's a very different consideration. Okay. But that turns on the evidence and the upper tribunal's findings. And Mr. Hewitt's expert evidence was that he could see no reason why Mexford House could not secure a tenant in the future.
The question I was putting to you was really more concerned with, was one of law rather than one of evidence. As a matter of law, do you hypothesize a situation in which, other than the subject property, the other properties in the locality are actually let on the terms on which they are in reality let?
So I think the answer to that must be
If it helps you,
it is yes. Sorry,
I'm rather rusty on this myself, but I thought I have a vague recollection of there being authorities to the effect that you assume that the statutory hypothesis is of a situation where all properties are to let on the same date. But I can't cite you an authority for that. Now, I may be wrong. That's my recollection. Anyway, there's a right or a wrong answer to it anyway, as a matter of law.
So there is a Scottish case that touches on this question.
Yeah.
But it's not binding, obviously, and the law is slightly different.
Yeah.
It strikes me that if the basic principle is that you look at
And I think, my lord, that was what I think I was trying to say, that the real world market demand, you look out, if you're valuing Hesketh House, at what is the actual status of the properties in the market at that time. So you value Mexford House on the basis that it is vacant and to let. So if, say, with Hesketh House, you ignore the terms of whatever the actual tenancy is, you ignore any restrictions, anything like that imposed by the actual tenancy, and you value it as if it was vacant and to let, but taking into account the actual real world general demand in the market.
Yeah. Yes.
I thought
I'm
one
sorry, I
of the
think I
things I referred
misunderstood
to subsection 7E, it seemed to assume that you were taking into account the use and occupation of other premises as they were at a particular time, but saying it is at the material date rather than the AVD.
So market demand is a feature that is taken into account at the AVD, but any physical characteristics that are observable in the locality, so for example the fact that some heritagement is next to the pub, which may be noisy.
Yes, I know,
like
but I mean it talks about occupation, which suggests you're concerned for all purposes with the occupation of, at least you assume that the property is occupied as it is. Which slightly goes, I mean, if there's a Scottish case which touches on it, I think we ought to have a look at it, because I'm not conscious that the Scottish law would be any different to English law in this respect.
So, my lord, this is the case of Barrett that we mentioned. Perhaps it's easiest to look in our written case. This is MS page 82.
You certainly, there's no doubt you take account of the fact that, for example, a public house is occupied as a public house. You don't ignore the fact that that's, if you're valuing a dwelling house, you don't ignore the fact that it's next door to a pub, for example. And ditto, the same principle would apply with business premises. All I'm wondering about is the way in which Lord Briggs put it a few minutes ago would suggest that you certainly take account, for example, of the fact that the level of demand for offices is lower in Blackpool than it is in the City of London. You take account of that.
Yes.
Where you're liable to get into trouble is if you assume that such demand as there is has already been exhausted by the occupation of other premises.
So I think, I apologise, my lord, I think I was previously misunderstanding your question. The quote from Barrett, which is paragraph, we set it out in full, paragraph 88 of our written case, MS 82. I think this might answer your lordship's question.
Yeah.
In valuing to net annual value on the statutory hypothesis, the assessor in this court must assume that no one holds lands and heritages on any tenure other than letting on the statutory terms. In this hypothetical world, the proprietor of subjects is assumed to be a possible tenant. One ought not to assume that in such a world, owner-occupiers or owners of timeshare interests would not be potential offerers of the tenancy. In the hypothetical world, one assumes that the demand is available to meet the supply.
Well, that's important if that's correct. Is it common ground that that is correct? Or will...
No, I think my learned friend has points that he will make in due course as to why they disagree with that. But then,
I mean, one might have to look quite widely in that case to see the context in which that's being said.
yes. Would it be possible? I'm just conscious of the time to continue going through the facts and then deal with the law all in one go. So I think we were just looking at our reply on MS 356. We'd paused on paragraph 6, and I just wanted to draw your lordship's attention to paragraphs 7 and 8b. The way that we put our case is if we are right, and as a matter of fact, Mexford House isn't obsolete, then we say that the rateable value of 370 is right on the evidence of rating assessments on comparable properties, and that is our 8B. 8C. There was a statement of agreed facts and issues, but it wasn't very illuminating at all. You can see the issue, so this is MS page 363, paragraph 25. The issue is simply very generic, what is the rateable value? Now, at this point, it's relevant to turn up the expert evidence. So if I could ask your lordship please to turn to page 394. This is the first expert report of Mr. Hewitt on behalf of the VO. MS 399, paragraph 6.2. Mr. Hewitt notes that vacancy doesn't mean a nominal rateable value where comparable properties are occupied at substantial rents. And again, you'll note the use of our shorthand. Refer to comparables to establish that there was market demand for the appealed property. Of course, what we mean is demand in the market for property of the same type, location, etc. as the appeal property. Paragraph 7.8, MS 401, there's some evidence about the marketing campaign, including the fact that there was subsequently an economic downturn after the AVD. And so Mr. Hewitt's opinion is that absence of a later letting does not mean absence of market demand at the AVD. So just pausing there, my lord, our position was that just because the property later failed to let, that does not mean that had the situation remained as at the AVD, it would have failed to let in perpetuity. And this goes back to my point about the reasonable prospects that the hypothetical landlord would be entitled to take into account as to future happenings. So paragraph 7.9 begins a section on supply and demand at the AVD and comparable assessment evidence. And on MS page 402, right at the top, you'll see a reference to 24 office hereditaments being put forward initially. There were various different sizes, and I think how the evidence develops is that a smaller number were properly comparable, and Hesketh House was the most closely comparable.
Sorry, where is this? Top of 402?
Top of 402.
Thank you.
24 office hereditaments on the filed. Third paragraph down, Mr. Hewitt notes that at the AVD, none of these offices were vacant. And then he says this: the stock of office hereditaments in the locality represents the supply. The evidence that all of the hereditaments across a range of types and locations were occupied at the valuation date demonstrates demand. This is clear evidence at the AVD that there was a good balance between supply and demand. Moving forward, you can see the subheading paragraph 7.10, functional obsolescence. Mr. Hewitt's evidence is that, in particular, Mexford House wasn't functionally or locationally obsolete, and he goes through this in detail, these two particular issues in detail, not least because they were the key matters that Telereal had focused on. Well, Mexford House's size, etc., is just wrong. Mexford House's location is undesirable, so he explains why he doesn't consider that either of these lead to obsolescence. Paragraph 8, he sets out his opinion of value. This is MS 409. He notes the rent passing of 417 at the AVD. He notes at the bottom Hesketh House. The agreed rent was just over £70, and the rateable values come out at £59. And he goes through and summarises his opinion in relation to each of the comparables. And then his conclusion, this is key, in support of my opinion that the subject property was not obsolete.
Sorry, where is...
I'm sorry, this is conclusion, paragraph 9, MS 411. He sets out a number of factors, and I quote, in support of my opinion that the subject property was not obsolete at the AVD. And that's important because there's no qualifying adjective there. His conclusion is that Mexford House is not obsolete. If I could ask your lordship just to turn up my learned friend's written case, so this is Telereal's case, and go to page MS 98, please.
MS
98. This is where this term economically obsolete is introduced. As a third type of obsolescence, we don't agree that it really is strictly a different type of obsolescence to the way that we've used it. This is paragraph 15, last sentence in paragraph 15. And then at paragraph 17, Telereal says this: those three uses of the term obsolete are not mutually contradictory. The qualifying adjective is critical. It was not a necessary part of the ratepayer's case to show that Mr. Hewitt's propositions were wrong, so he was not cross-examined on them. Now, just pausing there, it's clear from the conclusion that Mr. Hewitt is basing his opinion not merely on functional or locational obsolescence, but his conclusion in line with our pleadings is Mexford House is not obsolete, whatever qualifying adjective one might want to put in front. So if Telereal wanted to challenge that evidence, they would have needed to have put it to him in cross-examination. And it's accepted at paragraph 17 that they did not do so. And we say that as a result of their failure to cross-examine Mr. Hewitt on obsolescence, we were entitled to proceed on the basis that obsolescence was no longer being pursued by them, especially when we are now told that it's a point of law dictated by the terms of the joint position paper, which say nothing at all about an agreement that Mexford House is obsolete, not least because that wasn't agreed and that was never put. Mr. Hewitt's expert report, the second expert report, is at MS 415. And just looking at some of his general, I should say to start off with, in this document, the word obsolete is used several times without any qualifying adjective at all. So we say it's patently clear that that was our case and that was his evidence. And Mr. Hewitt was not confining himself to certain subsets of obsolescence. He makes general comments at 3.1 and 3.4 in relation to Mr. Baldwin's witness statement. And it's clear from these paragraphs, so this is MS 416, that he interprets Mr. Baldwin's evidence as essentially that Mexford House is the worst, so it can't be said to be properly comparable to other offices in the locality. At 3.3, he says, I believe I can demonstrate that the subject hereditament had a significant value at the relevant time, as demonstrated primarily by the occupation of comparable hereditaments in the locality. And then 3.4, he makes the point that there isn't proper evidence to distinguish Mexford House from the comparables. Now, over the page 3.6, he notes that Mexford House, this is paragraph 3.6, MS 417, Mexford House was not vacated because it was no longer suitable to be occupied as an office. There's no reason to believe this, and there are no identifiable features which support such speculation. So his evidence was it's still suitable to be occupied as an office. And then 4.9 is important.
What is the authority for this first sentence of 3.6?
So I'll be taking your lordship to that in due course,
we'll
in particular the case of Dawkins and Ash. Paragraph 4.9 is critical. I believe that Mexford House is a perfectly serviceable building, and there is no reason that it could not be reoccupied and used for office purposes. The fact that it has become vacant is no reason to treat it differently. The evidence demonstrates that demand and supply for office hereditaments of this size was closely matched at the relevant time. The subject is not clearly distinguishable from the evidence provided, etc. And we say again you'll see from the Upper Tribunal's decision, there's no record of the Upper Tribunal either recording a challenge to this or indeed finding against this evidence. And against that background, we say that that needs to be taken as accepted because the joint position paper arose after my learned friend had finished his cross-examination of Mr. Hewitt. Over to page 424, paragraphs 4.31 to 4.34, essentially what's being considered here is, whilst in certain respects the characteristics of Mexford House may be less advantageous than certain other properties, that is not to say that Mexford House is obsolete as a result, and that conclusion is over the page 4.25, sorry, MS 425, 4.36. MS 426, 4.41, Mr. Hewitt refers to the reports in Mr. Baldwin's expert evidence, and they demonstrate that market conditions changed significantly after the AVD.
Sorry, this is 4.37?
4.41.
4.1, thank you.
Over to page MS 429, 4.57 and 4.58 are important. The subject property becoming vacant is not a change within the rating hypothesis and in any event does not make a property obsolete. So again, no qualifying adjective used there. 4.58, paragraph 4.58, as accepted by the respondent, Hesketh House is no better than Mexford House, and yet they do not consider it to be obsolete. And then finishing off, MS 433, paragraph 5.4, Mr. Hewitt summarises his position in line with Mr. Baldwin's evidence. If Hesketh House is no better than Mexford House and it's not obsolete, then what is the basis for treating them different? They shouldn't be treated differently. Now, there are a handful of paragraphs that it is useful to see in Mr. Baldwin's evidence. So this is Telereal's expert. That begins on page MS 436. It's notable that in neither of his reports does Mr. Baldwin refer to the notion of economic obsolescence. That's been introduced for the first time in Telereal's written case. MS 440, please, 440. The essence of paragraphs 2.3 to 2.5 is to say Mexford House is the worst. It's not comparable with any other hereditament, and that is why it is destined to remain vacant. This is 2.3 to 2.5. Moving on to MS 449, please. And alighting on paragraph 8.3, even on Telereal's own evidence, Mexford House was handed back because of a surplus, not because of any particular deficiency. And that's also at 8.6, paragraph 8.6. Now, moving forward to MS 462, paragraphs 11.8 through to 11.10 are important. At 11.8, Mr. Baldwin notes that he's considered the comparables, and none provide any evidence to refute his opinion that Mexford House is obsolete. At 11.9, the reason for that becomes clear. It's essentially because, other than that they were all classed as offices, they have little in common with Mexford House. So he is not accepting at this point that Hesketh House and others are proper comparables. So the fact that Hesketh House is not obsolete has no bearing on the obsolescence or otherwise of Mexford House, in his opinion. Now, he then at 11.10 refers to once a decision had been taken by the government to vacate Mexford House, it becomes obsolete. We don't accept that. It becomes vacant. It doesn't necessarily become obsolete if there is no deficiency inherent in Mexford House that makes it such, especially when other comparable properties are occupied. And I should say at this point, there's no evidence whatsoever to suggest that the other comparable properties are being occupied under protest because all the tenants are locked in and can't vacate. There just isn't any evidence of that. Now, MS 463, paragraph 11.14, here, Mr. Baldwin is saying that Hesketh House, although it has some physical similarities, then the last sentence, it differs from Mexford House in that it is not obsolete. So it's very clear that Hesketh House is not being put forward as obsolete, and Mr. Baldwin's evidence is Hesketh House is not properly comparable with Mexford House. So there is no evidential basis to adopt the 59 per square metre value because they're not comparable. Now, just by way of passing, Mr. Baldwin sets out his evidence in section 12, that's MS 465, in relation to the nil rateable value properties, but this wasn't in any way pursued, not least because these properties are certainly not properly comparable because they're not in the locality. And then his conclusion, page MS 468, paragraph 31, there's no demand for a tenancy, essentially because Mexford House is too big, completely outdated, and so on. And so that is why no one wants Mexford House, distinct from the other properties that are occupied. Just one paragraph in his second expert report that's relevant. So if we can pick this up on MS 481, please. R26, the fact that each of the comparables was occupied indicates demand for that comparable. Then R28 is important. He agrees with the appellant that there was overt demand for Hesketh House and that that is evidence of value. And he repeats this point essentially for most of the public sector occupations referred to by the VO. Now, if we may look briefly, please, at the way that the skeleton arguments were developed,
You may be coming to this, but Mr. Hewitt said that it was accepted that Hesketh House was, quotes, no better than Mexford House. That's at page 429. Where does he get that from? (429), paragraph 4.58.
I think this comes from the evidence about physical similarities.
Well, no, I mean, he's clearly quoting, quotes, no better, which I assume, and he does it again at 5.4. It's obviously a very important part of his approach, that it's common ground that Hesketh House is, quotes, no better. I assume must come somewhere in the... Well, don't worry now, if you want to come back to it.
On any view, that is taken to be accepted by the time that the joint position paper is agreed, precisely because that is where the comparable rent of 59 per rateable value of 59 per square metre comes from.
Anyway, see, I mean, if there is a... It seems to be quoting something. It'd be surprising if he...
Yes, thank you. Yes, so it's MS page 463.
Oh, I see, the location. Fleetwood is no better.
The location is no better and also does have physical similarities.
Yeah.
I see.
Yes, he said, I mean, having said that it has physical similarities and that it's a very unattractive building, a poor location, Fleetwood is no better than Blackpool, and so forth. But he ends up saying the property differs from Mexford House in that it's not obsolete. He then goes on the next paragraph to say that if the NHS decide to move, the building would become obsolete. So really, when he talks about buildings being obsolete, he really means that they're unoccupied and unlikely in the real world to find a tenant.
So, as to the first point, we say yes, he means unoccupied. As to the second point, we'd accept that that is what he means, but there was no actual evidence of this.
Yeah. And I suppose it all depends on price. I mean, if you have a choice between Hesketh House at 400,000 a year and Mexford House at £1 a year, the NHS might perhaps think about it.
Which is precisely why we say it's not appropriate to say that the rateable value of Mexford House is £1 a year, because that just blows apart the principle of uniformity. We also say that this notion of becoming obsolete isn't necessarily correct. If something is obsolete, it can be occupied and obsolete, but if it is genuinely obsolete, the rateable value of that property, occupied or not, would be nominal, because it is obsolete, because it has that quality. If the occupier happens to be forced to stay there, the fact that he is forced to stay or he isn't able to terminate his tenancy of an obsolete property does not all of a sudden give the property value if it is truly obsolete. So we say that this is slightly confusing the principles and what is meant by obsolete and what is understood in cases.
Yeah. I mean, it rather sounds as though, on Mr. Baldwin's approach, if the NHS were to give notice and leave Hesketh House, the owners would then be entitled to seek a revaluation of the property on the basis that it had thereby become obsolete. And
that isn't correct. That isn't correct because there's no basis for seeking a revaluation, precisely because simply vacating a property is not one of the para 27 factors that enables a material change of circumstances that allows there to be a revaluation. So Hesketh House is either obsolete or it's not. That's to do with its state, and it's got nothing to do with whether it's occupied or not. The two are not synonymous, and that's important. Now, if I can turn very briefly, before we get on to the upper tribunal decision, to Telereal's skeleton argument in the upper tribunal, where they summarise neatly how it is that we put our case. So this is MS page 383. And it's paragraph 21. And essentially, paragraph 21, how it is we put our case, is the background for the joint position paper.
I'm so sorry, I've got the page number wrong. Could you give me the MS number?
MS 383.
Thank you.
Paragraph 21.
Yeah.
So this is Telereal's summary of our position before the upper tribunal. And we say that the notion of general demand and how it is that we are saying general demand is relevant is properly encapsulated in these paragraphs and essentially goes on to form the basis of the joint position paper.
So, let's see. So this is Mr. Glover's summary of your case?
Yes.
And you accept it as accurate?
Well, we say that this is exactly how the case then proceeded before the upper tribunal, which is very different to how Mr. Glover is now seeking to put his case here.
Yes, but it's an accurate summary of how
Yes.
you were putting your
Yes.
case.
When he sets out his response, it's notable that whilst there's mention in paragraph 23 of obsolescence, and Telereal's position is, well, maybe you can have an academic debate about that. Actually, the case is mainly put on the footing of oversupply or market saturation, and you can see that from page MS 385, essentially paragraphs 25 through to 28. So essentially, this embodies an oversupply or market saturation case. And that is exactly our understanding of it. And we say when we look at the upper tribunal's decision, which we're going to go on to in a minute, that was clearly their understanding of the case as well. Just alighting finally on paragraph 33, the summary of the evidence, no potential tenant who would have leased the appeal hereditament. But of course, this is remembering that Mr. Baldwin's assessment is based on his evidence that Mexford House isn't comparable with any of the occupied properties. Now, if I might move on to the upper tribunal decision, please. And this starts at MS page 161. If we could go to paragraphs 18 and 19, we say that the upper tribunal's summary shows plainly that they understood Mr. Hewitt's evidence to be that Mexford House wasn't obsolete and that the mere fact of vacancy does not justify a lesser value. So it's immediately clear, we say, that the upper tribunal understood this to be a market saturation or oversupply case. The evidence at paragraph 24, MS 167, essentially is no different to what became paragraph 3 of the joint position paper. Mr. Hewitt accepted that he could not identify in the real world any person who would put in a bid for tenancy. There was no demand from the private sector and public sector demands were being met. So that was the basis for it. Nothing to do with any intrinsic quality of Mexford House. And paragraph 29 is also important. This is key. It is clear from 29 that the upper tribunal interpreted our position correctly as being that Mexford House should be valued by reference to other comparable properties. And it's also clear that the upper tribunal understood our case to be no demand because of oversupply. And that is the fifth line up. He said that the fact that as at the AVD there was in the real world no demand, brackets, because all the demand had been absorbed, was not because of any intrinsic lack of merit or obsolescence. Now, that is the background against which the joint position paper is then agreed.
Do we in fact have the transcript of the cross-examination?
No.
I'm not asking you to go to it, but in case one wanted to have a look at it.
No, we don't. There wasn't a transcript of the upper tribunal hearing, so we're having to work from how it was summarised in the evidence. No.
I mean, the tape recorder must have been running, sure.
Well, in that case, we haven't obtained a transcript.
I mean, one could get one if one wanted.
Yes, I suspect one
no
could
one
if one
has.
asks. No one has. Well, not least because on any view in the written case, my learned friend has accepted that they put no questions to Mr. Hewitt about obsolescence.
Can I interrupt you just for a moment? I found the authority that was at the back of my mind. It's Lord Justice Wilmer in Humber and Jones. We've got it. It's MS 970. It's tab 25. And he's dealing with a somewhat similar argument where if you hypothesize in the context of the real world, you're going to end up with a nil valuation. And on page 970, the right-hand column, last 9 lines, he says the fact is that it's impossible to get away from the situation that the statute postulates not only a hypothetical tenant but also a hypothetical landlord, and as the Lands Tribunal said in the passage cited, in the context of a hypothetical world in which the hypothetical tenant cannot become the owner and cannot get a lease for a term of years. Moreover, one has to postulate a world in which not only this hypothetical tenant is in that position, but everybody else is in the same position. That was the passage I had in mind. Just mentioning that, but I don't want to interrupt your argument.
Okay. I wonder, once I've got to the end of looking at the issue, I might ask my learned friend who has some submissions on Barrett, who could also touch on that point before I go on to the law. That might be most convenient.
Yes, I'm keen. I mean, we seem to have got the factual situation that, I mean, your valuation officer is clearly proceeding on the basis that the fact that there's no actual demand for this property doesn't matter if there's a general demand for properties which are comparable to it, such as Hesketh House. And, you know, the real question for us is whether that's right or wrong, isn't it?
And pausing there, the terms of the joint position paper are set out word for word, MS page 169. So paragraph 3 of the joint position paper, the parties agree that had the subject hereditament been on the market, no one in the real world would have been prepared to occupy the property at a positive price. That essentially summarises the upper tribunal's understanding of the evidence that I've just taken, Your Lordship, to paragraphs 24 and 29. And then the other key paragraph is paragraph 5b, If the correct approach is to assume a hypothetical tenant, which Telereal accept, and requires rateable value to be assessed by reference to the general demand as evidenced by the occupation of other office properties with similar characteristics, then the parties agree that rateable value should be 370. And we say that in reaching this agreement, Telereal effectively compromised on 2 points. First of all, that Mexford House was comparable to occupied properties, most closely Hesketh House. And secondly, and necessarily, neither of those two could be obsolete, because there's no world in which you could get to an agreed figure of 370 if the opposite were true. And we can also see that that is accepted in effect, in substance, when we look at paragraph 36, the last 5 lines of the upper tribunal's decision.
Sorry, page.
MS 171, paragraph 36, the last 5 lines.
Thank you.
And so, in essence, the upper tribunal can be taken as having decided that in the absence of any actual prospective tenant as at the AVD, because all the demand has been absorbed in the other comparable properties, it's permissible to assess rateable value by reference to general demand as evidenced by occupied comparables. And once the background to the JPP is made clear, that, in essence, is what the upper tribunal is taken to have decided, and indeed did decide when it made its decision about 370. And we say that that's plainly correct, and I'm about to move on to my propositions of law, so I wonder if this might be a convenient moment for my learned friend just to make some short submissions on Barrett before we do so.
Well, it's really a matter for Mr. Glover.
I'm sorry. I meant my learned junior.
I beg your pardon.
I'm sorry. I was inviting my learned junior to make some short submissions on Barrett.
Yes, certainly. Mr. Flanagan.
Grateful. My Lord, the question posed by my Lordship was when valuing the subject property, what does the law require you to take into account about the other properties? In particular, do you assume that the tenants of those other properties or the occupiers can't constitute relevant demand because they already have their own property, i.e. the demand's been exhausted or satisfied? The short answer is we say it is fundamental to valuation for rating that you do not assume that. And I have a reason in principle as to why that's right, and then I'll, as my learned leader says, explain why that's right, reference to Barrett and the authorities. The reason in principle is because it would be incompatible with the uniformity principle. You would no longer have what the authorities call a common yardstick for valuation. You would have comparable properties having wholly different valuations, i.e. comparable in the sense of age, location, type, intrinsic qualities, but having wholly different valuations. Hesketh 370,000, Mexford nominal nil, despite being materially the same in terms of intrinsic qualities. So it is incompatible with that principle. An example of that,
where do you get that principle from?
The principle of uniformity is, we set out the authorities in our case. We have it under...
I think you have it on MS 77 in paragraph 72 of your case.
I'm grateful, yes.
You collect together a number of dicta.
Yeah, so we've tried to digest the authorities under the common yardstick, as we call it, the heading. So Dawkins, Poplar and Williams are the three key ones.
Yeah. I mean, there's a ladies' hosiery case which tells you, as you have on the other page, about not sacrificing accuracy in the interest of uniformity.
Absolutely, and the Court of Appeal relied on that, and we say that the significance of that is that if the properties are not truly comparable, then they must be valued differently, and Ladies' Hosiery tells us that.
Yeah.
But in this case, Mexford and Hesketh are properly comparable.
Yeah. Thank you, that's very helpful.
My example, just to conclude on the reason in principle, is that if, for instance, you have 10 properties in the market, but only 9 tenants, that would appear to be a relatively buoyant market with a good balance of supply and demand. But if you assume that all those other occupiers are stuck, can't move, can't constitute demand, then the 10th property gets a nominal value, whereas all the other 9 get a substantial value. That is, we say, that can't be right.
But if all the tenants are stuck in the other 9, why do they get a substantial value? Why is the evidence that they individually are occupied by tenants who can't leave tell you anything about what the demand is for that property?
Yes, but indeed, valuing those other properties, one would take them vacant as to let, and one would look at the 10 properties, 9 tenants, and that would...
But I mean, I was just looking at the real world fact that all the other 9 were occupied by tenants who couldn't leave because they were not in for terms of years. They were in for terms, not yearly tenancies.
But the object of rating is to apply a common yardstick evaluation based on intrinsic qualities of age, location, type, and those sorts of matters. And therefore, it should be those matters which determine value, not the accident of whether the property's got one of the 9 tenants or not. And one can test that, because if it's right that you have to assume those other 9 are stuck, tied, that would mean, essentially, that the value would change depending on how you shuffle around those tenants or those occupiers. Whereas, in fact, the properties are still, Hesketh is still comparable in terms of its qualities to Mexford. So that's the reason in principle. I say the authorities, be very brief on this, they are at MS, can I take them from MS 81 to 82, which is our written case, and there are 3 authorities. The first is at the top of MS 82, which is the authority of Humber and Jones, which Lord Reid has just referred to, dicta of Lord Justice Wilmer. Just pausing there, we rely on Lord Justice Wilmer's dicta, the reason my learned leader gave. It's correct to acknowledge there is dispute about what Lord Justice Wilmer was saying there. In particular, in the second line of his quotation, the words, everybody else is in the same position. Does that refer to every other occupier of every other property, or does it refer to every other hypothetical tenant for this property? So it's said against me that it's not clear, in fact, that Lord Justice Wilmer was supporting the proposition I advocate.
He was talking about whether you make a yearly tenancy assumption, wasn't he?
Yes, it looks like that.
It's quite a focused point on what kind of tenancy does the statute require you to assume in relation to relevant comparable property if it's occupied?
Yes.
I mean, it's not a very substantial quote, that.
No.
I think you've got to look elsewhere.
I accept that, and there is limited authority on this. The second is even more limited, I'm afraid. It's paragraph 87 in the Wyre Forest case, just to note that this argument was raised but not decided. Therefore, I don't pause any further on Wyre Forest. And the third case is the Barrett case, which my learned leader referred to. Again, I accept, of course, that it wasn't directly dealing with the issue in our case. But broadly, I say Lord Gill's comments there do support our case in that it indicates one has to assume the demand is available to meet the supply, Lord Gill's words. If you assume that the other occupiers cannot constitute relevant demand because their demand has been satisfied, then you're not assuming the demand is available to meet the supply.
And your case is it's really a necessary result of the uniformity principle, which is well established in the authorities you cited.
Absolutely, and that is...
These are sort of illustrations of it, but none of them are crystal clear, and none of them are binding on us.
No, I accept that. And the only other authority which I should refer to is that the contrary authority against me is cited by the respondents. It's page MS 125, case of Hoare and National Trust.
Yes.
And at the top of, that's where it starts.
Is that the Petworth House case?
It is, yes. At the top of MS 26, dicta of Lord Justice Sheeman is set out. And the emboldened words are relied on, as I understand the emboldened words. He did not submit this, Mr. Holgate, did not submit that the statutory hypothesis compels one to assume that in the real world no other property in the country would be available to National Trust save on the statutory terms. I think he was right not to make this submission. My response to that is that it is not clear that the Court of Appeal was saying that occupiers of comparable properties cannot constitute relevant demand if their demand has been satisfied. And particularly if you read the rest of that paragraph after the emboldened words, it says the hypothetical bargaining to establish the hypothetical rent would take place in a world in which the trust owned a number of properties, desired to acquire a freehold, and a number of other properties, etc. It appears to be, in my submission, a comment on the need to take into account the actual characteristics of the potential hypothetical tenant, i.e. the National Trust in that case take account of their landowning. So I say it's not necessarily support for the respondent's case, and even if it is, I say it would be incompatible with the common yardstick approach which I advocate. Thank you.
I'm grateful to my learned junior. Moving on to the 6 propositions of law which we say are key. First of all, the common yardstick and equality of rating is absolutely fundamental. Second of all, one must assume a hypothetical letting, even if it may never in fact occur, and actual rent is not the true criterion of value.
Sorry, if you could go a little slower while I'm...
One must assume a hypothetical letting, even if it may never in fact occur, and actual rent is not the true criterion of value. Third, one has regard to each property's intrinsic characteristics and disregards characteristics that are merely accidental. Fourth, one must value on a vacant and to let basis, which therefore avoids vacancy leading to different valuations to incomparable properties. Fifth, the landlord must be a prudent man of business who's not over-anxious, and the hypothetical tenant must be assumed to be willing. And sixth, valuation for rating represents a higgling of the market that takes into account of supply and demand. And so in our case, there may be an excess of supply that may push value down in relation to all comparable hereditaments, but it doesn't remove it. So my first 3 propositions are all encapsulated in the Dawkins and Ash case, and that is Authorities Bundle 1, Tab 3, MS 546.
Could you just give me the page number of your case in which those 6 are set out?
Well, the 6 are not set out in that order,
Right.
but they are in the sections where we set out our where we set out 9 propositions, and that starts at MS 69.
Thank you.
And I've distilled them into the 6 that are most fundamental. So Dawkins and Ash, this concerned land subject to a demolition order. Was the probability that a part of the hereditament would have to be demolished within a year a relevant consideration in ascertaining value? So that is a question of looking at what might happen in the future. Is that a relevant consideration? The House of Lords in that case held yes. And if I may start off then by going to Lord Pearce, MS 561, please. And it's the foot of MS 561 by H. And this is the phrase, rating seeks a standard by which every hereditament can be measured in relation to every other hereditament. It's not seeking to establish the true value. Over the page, MS 562, top of the page, Lord Pearce summarises the position that even where you have hereditaments that are not let from year to year, you must nevertheless assume a hypothetical letting in order to do the best you can to arrive at value. And then just underneath B, there's a reference to human realties needing to be taken into account. They're excluded insofar as they're accidental, and they are acknowledged insofar as they are essential. And pausing there, it might be essential to Mexford House if Mexford House was no longer suitable to be occupied as offices, and that was the reason that HMRC had moved out. But it's accidental to Mexford House that HMRC, and not, say, the NHS, happened to be the tenants at the relevant time, and HMRC took a decision personal to them that they wanted to reduce their office stock, and that decision was personal to the revenue, not to do with Mexford House. So we say that shouldn't be taken into account. And in that particular case, the demolition order was considered to be essential, not accidental. Moving then on to Lord Wilberforce, please, at page MS 565. From G down to D on the following page, essentially what Lord Wilberforce is saying here, and this is at A, you can't suppose that the hypothetical tenant is imprisoned in the present and can't anticipate what may or may not come. And this is what we rely on in relation to our hypothetical landlord and the hypothetical tenant. They need to be looking at, as at the 1st of April 2008, as to what may or may not be round the corner and how that may or may not affect supply and demand. And in our case, relevantly, there is no finding by the upper tribunal that Mexford House, in fact, was never going to be occupied ever again, and it was understood that that was so by everyone at the 1st of April. There is no finding to that effect. We say, therefore, it is reasonable for both the hypothetical landlord and the hypothetical tenant to have in mind the likelihood of a future letting, and that is why the hypothetical landlord, 1st of April 2008, is not going to accept rent for £1 in a world in which, through no fault of Mexford House itself, HMRC have vacated, having previously been paying a substantial rent, when he looks around and sees a reasonably buoyant market with other public sector tenants, all of whom are occupying comparable properties, he has no reason to believe at that point that a tenant won't come forward. And so why is he going to accept £1 for Mexford House today? Lord Pearson then makes a similar
But I mean, no valuer, when looking at market value as at a particular date, confines himself to asking whether it would be offered that very day. Indeed, most valuations often give you some help as to how long it's going to take to get the sort of RICS best advice available on the market within a reasonable time, and that the whole exercise operates within a time frame rather than by reference to a particular day of the month.
And in our
Rating, I know rating has to be done by reference to a valuation date, but I mean, it doesn't depart from that ordinary common sense approach.
in terms of at that date, you can look out and see what may or may not happen.
Yes, I mean,
Yes.
it may take
And-
2,
and
3,
we say
6 months to get your tenant. It doesn't mean to say it doesn't have a value on the first day.
Right, yes, and one can look at all the houses. I appreciate housing is not for rating, but one can look at all the houses advertised online and see how long they've been advertised online. They're not worth zero, simply because, notwithstanding they're open to the world at large to see on the internet, they haven't been bought today. That's exactly right. So we say that is absolutely a relevant consideration, and it is supported by what is said in Ash and Dawkins. Moving on to Lord Pearson, the bottom of 569, Lord Pearson touches on the case of Poplar, and in short, in that case, that concerned the Rent Restrictions Act, where the landlord in question could not seek more rent from the tenant, so the rent was restricted. But in that case, the fact that in law the rent was restricted was not to be taken into account for purposes of rating, because one had to evaluate the value of the occupation. And critically, by 570b, quoting from Poplar, just as the tenant is hypothetical, so also is the rent. It is only used as a standard which must be examined without regard to the actual limitation of the rent paid by virtue of covenant as between landlord and tenant. So it's not right to say that the deal between the landlord and tenant in any way can affect the rateable value, because that is an accident, just as it is accidental whether or not HMRC decide to vacate Mexford House as opposed to one of their other properties in their stock. Over the page at the top of MS 571, just by A, there's the recording of the finding about it being known or reasonably anticipated that demolition could be on the horizon. And then my Lord Briggs's point, I think, is picked up 572, B through to E. Just by C, there's a reasonable expectation, a probability that demolition would take place. And so therefore there's an external risk, and then D, between D and E, because of that risk, which was regarded as a probability, the hypothetical tenant would be willing to pay only a reduced rent. And this notion of present probability of a future happening and how that affects the present value is encapsulated very neatly, page 573, E through to G. Just by F. There is in this case a present probability of a future happening, and the present probability affects the present value of the hereditament. And then top of page 574, by A, the mind of the hypothetical tenant would be affected by the prospect that within about a year he would probably lose a portion of his premises. So we say Y2, in the real world, is the hypothetical landlord not allowed to think to himself, well, given the circumstances as at today's date, there is a reasonable prospect of a future letting when I look out at all the comparable properties. It's an accident that HMRC has vacated, and therefore, abiding to the principle of the common yardstick and uniformity, we can't have a world in which Hesketh House is comparable and rated at 370, and Mexford House is rated at nil or nominal. If I may touch on the reasoning in Ladies' Hosiery very briefly.
You've only got 5 minutes left. You are going to at some point point me to the authority which says you have to have a willing tenant and a winning.
Yes.
And you've
Well,
got,
I'll go to
three
that
more
right
propositions
now.
to go through in 5 minutes. I'm just concerned.
So I'll go to that proposition right now in that case. If I may skip over, one must value on a vacant to let basis, because that's the words of the statute that requires you to do that. The hypothetical tenant must be assumed to be willing. This is first of all in IRC in grey. That is Authorities 1, Tab 6, MS 634. And the relevant quote starts on the top of page MS 646. Hypothetical vendor and purchaser do whatever reasonable people do. Just by little a, the hypothetical landlord must be a prudent man of business and cannot be over anxious. And then just by little e, it's often said that the hypothetical vendor and purchaser must be assumed to have been willing. But I doubt whether this adds anything to the assumption that they must have behaved as one would reasonably expect of prudent parties who had in fact agreed a sale on the relevant date. So that is the point about a willing hypothetical landlord and tenant. And it is also repeated. Authorities, tab 12, the case of Smith and Churchwardens. If I could ask your lordship, please, to turn up page MS 803.
Yeah.
And starting about 5 lines down, the sentence beginning the mere fact, that entire section is relevant just to the end, but I'm picking it up about 6 lines from the bottom. You must assume a landlord willing to let and a tenant willing to take by the year. And having done so, you must do the best you can to arrive at the rent.
So, I mean, you're assuming someone who wants a property, not... I mean, in circumstances when no one wants a property, you have to assume that someone at least is willing to take it.
And that is the basis of the hypothetical. That is the basis of the statute,
Yeah.
not least in order to conform with uniformity.
And then you imagine what you call the higgling in the market, which is talked about in one of the cases.
Exactly right. And that is, just to give your lordship the reference, I think the higgling of the market is reasonably straightforward. The quote simply makes it clear that that's the balance of supply and demand. The reference is Authorities 111, Robinson Brothers, and then the relevant passages are MS 772 and MS 774.
But I suppose in both cases, neither the landlord nor the tenant is over anxious. They're willing to get involved, and
And drawing all these threads together, if I may turn briefly to Lambeth, please. This is Authorities 1, tab 14. This is a good example of how a nil rateable value is arrived at in a case of obsolescence. It is clear from the evidence that the tenant moved out because the property was no longer suitable, and that is right at the top of MS page 834. The tenant was W.H. Smith. They wrote a letter to say why they moved out, because the property wasn't suitable. And then the proposition that has been cited with approval since then in Schielenborg Warner is on 837. And this starts, I accept the argument put forward by the appellant rating authority that the mere fact that premises are unoccupied does not of itself justify a lesser value than that applicable to similar premises which are occupied. It then gives the example of a parade of shops where one shop remains unoccupied. One would expect to find similar values applicable to all shops possessing similar characteristics. Now, pausing there, the tribunal goes on to consider why it was, first of all, that the warehouse was in fact obsolete on the evidence, and second of all, there were no other occupied hereditaments that were sufficiently comparable. And if I may just conclude with this point, this fits in line with what I've said about uniformity and so on, where you've got comparable occupied premises commanding substantial rents, and if it's admissible to take into account general demand, then the parties have agreed that the 370 figure is correct. The empty premises were materially different, and Hesketh House, which was comparable, was essentially, was agreed not to be obsolete. Against that background, the upper tribunal was right to reach the decision it did. The key paragraph, the key sentence, is at paragraph 106 of the upper tribunal decision. So that is 106, that is MS page 188. The key sentence is that the rent for vacant Mexford House, so this is 106, would be negotiated between the hypothetical tenant and hypothetical landlord by reference to the general demand for such properties, as evidenced by the occupation of other office properties. And when one looks at, for example, Horan National Trust, one sees very early on in Lord Justice Sheeman's judgment that it is entirely legitimate to value in this way. And just if I may, for your note, this is MS page 611. If I may just read it out, it's right at the bottom. Lord Justice Sheeman says, there is a number of methods of arriving at rateable values. Usually it is possible to arrive at a hypothetical rent by discovering what rents are being paid for similar properties and making necessary adjustments. That was not possible here because there was no rental market in similar properties. But that sentence is key. In Hoare, there was no rental market in similar properties, and that is obviously not our case. If I may just conclude, and I appreciate that I'm trespassing slightly on my learned friend's time, we say that the Court of Appeal was fundamentally wrong to, against that background, determine that oversupply necessarily meant nil rateable value. And we say that that is absolutely what the Court of Appeal did. First of all, when you look at how it decided the case, paragraph 41, so this is MS 153.
Is that paragraph 153?
MS 153,
Sorry.
paragraph 41.
Thank you.
But key to understanding how the court reached that judgment, MS 154, G to H, so paragraph 43G to H, Lord Justice Henderson says that he sees no reason to suppose that the result would have been different in principle if it were one of the comparable properties rather than Mexford House that had been vacated. In a saturated market, there is still a proper basis for a substantial rateable value, while the existing tenant remains in occupation and pays a substantial rent, but that situation changes once the property becomes vacant. So it is clear that what is underpinning the Court of Appeal's thinking is this notion of, well, it's accidental that Mexford House is the vacant property. Mexford House is therefore valued at nil, but if it was Hesketh House that happened to be vacant because the NHS decided to vacate, then it would be Hesketh House. And we say that blows apart the fundamental principles of rating, in particular uniformity. It is no help at all to point to the ladies' hosiery case, because in that case, the fact-finding was that the appeal hereditaments value was correct. And so in that situation, you're not even acceding to the principle of uniformity by giving the other properties wrong values. What you should be doing is bringing down or bringing up the wrong valued property. So ladies' hosiery is not the answer that Lord Justice Henderson thought it was. My lords, my lady, unless you have any further questions that I can assist with at this moment, those are our submissions.
Well, thank you very much indeed. I'm afraid we slightly trespassed on your time. Mr. Glover.
The arm wrestle will come later on rather than now. What I propose to do, if I may, in the half an hour before the short adjournment, is to take some short, important, broad points and then perhaps show a bit more structure when we come back after having eaten. The introductory points are, I suspect, 3 or 4 in number. The first is to point out, my lords, that in this case we are in an unusual situation. It is generally the case, not the case, that where you will be able to ring round a particular market, for want of a better word, and say the only potential candidate tenants are identifiable. Mostly in the real world, what you see is a market that's a lot more amorphous than that, in which there's a great deal of churn. And it simply ceases to be possible, other than in extreme circumstances, to say there is confidence that all parties can agree nobody has a demand to pay for that at more than a nominal value. So it would be, in my submission, a huge mistake to assume that whatever is meant by these decisions, and I'm going to say that my learned friends got it badly wrong, but whatever is meant by the Court of Appeal and the upper tribunal's decisions, they are going to lead to some sort of broad and magnificent and frightening effect in the City of London, for example. My lord, the second point is this. We have heard a great deal this morning about the parsing and defining of the word obsolete. For reasons that I will explain, I say that debate, interesting though it was, is entirely irrelevant to what your lordships have to decide. But, my lord, can I put to you, please, 2 examples? First, you have a property which is sui generis and which the valuers agree has come to the end of the road. Its next step is some sort of major refurbishment or redevelopment or something of that sort. Now, in those circumstances, as I understand my learned friend's submissions, she would accept that the rateable value of that hereditament becomes naught. It only actually becomes naught if this state of affairs has come about at the valuation date. If it comes about in any of the 5 years between valuation dates, the ratepayer is stuck because the demand is taken, as my own friend told you, at the valuation date, in our case, April 2008. So that's my first example. The second example is of a property which is not sui generis, but which is in a class. And the parties recognise, the valuers recognise, that this property's occupier having vacated, it is in exactly the same position as the previous example. It's not going to be let anymore. It will either be refurbished, redeveloped, repurposed. But ours happens to be the first, or one of the first, of this particular class to fall off the edge. And that happens in the real world because of the nature of tenancies and all sorts of practical matters of inertia of that sort. Now, it is an unavoidable, as far as I see it, consequence of my learned friend's case that the rating system pretends there is a demand for that second hereditament, which in reality doesn't exist. Now, I say that's fundamentally unfair. And I say that the whole system is designed to ensure that each ratepayer pays by reference to the value that is shown by the demand to occupy his hereditament. All sorts of items may be used in evidence to help you answer that question. But that is the question you answer. The third preliminary point then takes me, if I may, to the joint position paper in this case. My Lord, it's in various places. I'd ask you to look for it in one of the versions of the tribunal's decision, because I want to take you to things around there that the tribunal says. So that's page 200 in the core bundle, MS page 200. And the first point to note is that in paragraph 31, the parties approach, 3 or 4 lines down, inform the tribunal that having regard to the position of the appellant, that's Mr. Hewitt, as revealed through Mr. Hewitt's evidence the previous day, and particularly the matters referred to in paragraph 24 above, my learned friend took you there, I'm going to take you to look at it a little more closely. The parties were of the view that the issue between them could be decided as a matter of law upon an agreed basis of fact. We then have the joint position paper set out, and which I'll come back to, but could I just draw your attention also to paragraphs 33 to 37, in which in 33, 5 or 6 lines up from the bottom of the page, the tribunal says, we pointed out that if we proceeded as invited, we couldn't properly resolve any dispute of fact insofar as such was revealed in the evidence before us. The parties were both content with this position and considered that in the light of the factual agreement contained in the JPP, there was no need for any such resolution of disputed matters save for the point of law. And we see in paragraph 34 that there were 2 points that the tribunal would have raised and which my learned friend Ms. McCarthy said were no longer of relevance. In particular, at item B, my Lord, I think it was Lord Reed's point about whether it was simply a matter of price, whether ultimately if you got down to a low enough number, somebody would pay. For example, whether if it was cheap enough, the DWP and HMRC would have decided to stay rather than go. As regards both these points, paragraph 35, we were told by Miss McCarthy that the appellant didn't seek to argue that in the real world, Mexford House could, at the AVD, have been let at a positive price. See now paragraph 3 of the joint position paper, and that therefore points A and B above do not need to be investigated. And indeed, if one goes back to the joint position paper, the first thing one notices is that the parties are content that the issue can be decided as an issue of law. And as a result, we have to be, and especially in the context of the passage I've just read to you, we have to take it that the tribunal are not exercising valuation judgments when they come to their decision. The issue is one of law. They've told us that they can't decide disputed issues of fact. And indeed, it would be quite wrong for them, once the parties have identified this as an issue of law, to start making their own independent findings of fact. And to be fair to them, they didn't. But it would be quite wrong for my learned friend, I submit, to suggest that somehow they did exercise valuation judgment. There's another reason for that. When one looks at the position paper itself, again, one sees at paragraph 3, the parties agree that had the subject hereditament been on the market at the valuation date, that is the date at which, if any deal's done, a deal is done, and a deal has to be done, I accept that, nobody in the real world would have been prepared to occupy the property and pay a positive price. Thus, if the correct approach is as formulated in paragraph 2, namely the valuer is required to consider whether, had the subject hereditament been on the market at the AVD, anybody would have been prepared to occupy the property at a positive price, the correct approach on the agreed evidence is it's £1. Even if the tribunal, had it gone on to my Lord's questions about a race to the bottom, might have come to a different answer. And we see at item 4, the VO accepts that there was nobody in the real world who would be prepared to pay or bid a positive price for Mexford House. And what the VO sets up in paragraph 5 is the opposite pole. This is a binary document, the opposite pole, namely that the rating hypothesis, the law, requires the rateable value to be assessed by reference to this general demand. It's not that general demand is a feature that can be taken into account in assessing rateable value. It is that the hypothesis requires that that piece of evidence trumps all others. It couldn't be a question of, is this a piece of evidence to be taken into account? Because we've already got to the stage where all the evidence is in the permission paper, and the tribunal is not in a position to assess its view. Now, it is fair to say that in the Court of Appeal, Lord Justice Henderson, how shall I put it, sucked through his teeth about the wisdom of doing that. And seeing that we're here before you now, he may have had a point. But that is the position where we are at.
But on the JPP, there's a straight question, which is really, as you say, in B, 5B, does the law require the rateable value to be assessed by reference to general demand, or doesn't it? It's a yes-no question.
Yes.
And if the answer is in law slightly more subtle than that, where does that leave us?
My Lord, I find it difficult to give you a compendious answer to that, because it rather depends on what is the middle position you find yourself in. But in broad terms, you either decide for or against one of us, or you remit this to the upper tribunal with a direction that you will have formulated as a result of the conclusion you've come to. That is a most unhelpful answer, I recognise, but I suspect it's the best I can do, at least at the moment.
I mean, as the upper tribunal said, in the real world, most valuers do look at evidence of general demand in coming to what the rateable value or selling value or whatever kind of value it is of a particular property is. So that, in a sense, there's a sort of overlap between these two supposedly antipathetic propositions of law, because if a valuer was trying to work out whether anybody would have bid £1 or £2 for the rent under your paragraph 2, he would be an extraordinary person if he didn't take into account general demand.
My Lord, the question that I say needs to be answered is set out in the first side of this dichotomy, to ask whether, had the subject hereditament been on the market at the AVD, anybody would have been prepared to occupy the property or pay a positive price. I am not being prescriptive about the evidence you can and cannot take into account in those circumstances. So if you have a row of 5 shops, 4 of which are occupied and 1 of which is empty, the fact of the occupation of those other 4 may well be evidence, may well, in all the circumstances, be conclusive evidence or sufficiently persuasive to lead you to that conclusion, that there is demand in the market at the AVD, in the real world, to occupy at a particular price. That's fine. But if, having taken all of that into account, you come to the conclusion that you find in paragraphs 2, 3, and endorsed by the VO in 4, you've passed that point. And what the valuation officer is asking you to do is to then come back in and say, well, nonetheless, the law is going to trump the exercise you've done thus far. And so the law is going to require you to assume a demand.
Well, a willing tenant.
My Lord,
Can I just, before, as you're going to be breaking soon, the paragraph 104 of the Upper Tribunal decision, page 2, MS 219, is really the nub of where they thought you went wrong.
yes.
They say in the middle, about 5 lines, so the respondent then incorrectly now attributes to the hypothetical tenant a characteristic which is not justified, namely the characteristic of not wanting the tenancy at all. And now that was why I was exploring the question of how willing a tenant are you asked to assume.
The way
I think it may turn on that sort of issue.
The way I deal with that is this. First of all, it's a mischaracterization of my case, because what's agreed is that there is agreed to be an identified lack of demand at anything above £1. What one does not then need to do, because we're dealing with a tax, is to make any assessment of how big a reverse premium the landlord would have to pay before he got to a tenant. So I'm not saying there is no tenant, but I'm saying that if Lord Hoffman, as he became, is right in IRC and Gray, that the hypothetical tenant represents reality in that he stands, so I'm not reading the quotation correctly, but in that he stands for the demand in the real market. In those circumstances, the evidence shows that the tenant would pay £1. and that there is nobody who would pay more than £1. And there are authorities for the, in my submission, self-evident proposition that the fact that you assume a tenant does not also require you to assume that that tenant would pay a rent higher than is evidenced by the market. So the agreed position is that there would be a deal. It would be a deal between the landlord and he who represents the real market demand in the real world. And as the evidence shows, that represents a rental value of a nominal sum. I still have 5 minutes, which would be a crime to waste.
Yes, by all means.
So may I leave you, I hope I can get through this very briefly in time. I'll come back to it in a little more detail after the adjournment, with some headline propositions about the rating hypothesis, which are all supported in the authorities and are more fully referenced in our case. The first point is, and my learned friend acknowledged this, the assessment of rateable value is a question of fact. In the words of Lord Justice Scott in Robinson, primarily an economical, not a legal investigation. But perhaps the shining authority of that is the Mersey Docks case that's in the bundle. There are other Mersey Docks cases. The second proposition is that in assessing the rateable value, the question to be answered is, supposing they were vacant and to let, what rent might reasonably be expected to be obtained for them? That's Lord Herschel in Erith.
That's now in the schedule, isn't it?
It's not actually. The phrase vacant and to let I don't think is in the schedule. It's the tenants, it's the rent at which it's estimated the parties would agree.
Well, unless it's vacant and to let, I mean, how does that agreement take any concrete?
Because one assumes that there can be a lease, then there has to be, the landlord has to be able to give the tenant vacant possession. Yeah, that's simply the point. I just saying it from memory, I think it's not actually word for word in paragraph 2, but that is no matter. There are several, I'll take you back to Robinson after the break, if I may, but one quotation, the valuation arrived at should represent the figure at which the hypothetical landlord and tenant would come to terms as a result of bargaining for the hereditament in the light of competition or its absence in both demand and supply as a result of the higgling of the market. There is also then the proposition, which I will put colloquially, we take it amongst other places from National Trust, don't depart from the real world, save where the hypothesis requires. And that is an approach that is common not just to the rating system, but capital gains tax, inheritance tax, compulsory purchase. In particular, the rating cases leave these broad lessons, if I might. First, do not let the nature of the hypothesis lead you to leave out of account demand that's really there. So, for example, because it's a demand from an owner, and in the real world the owner is somehow prevented from taking a tenancy. There are several cases there, London School Board, Mersey Docks, Erith and Robinson. Next broad thrust, do not create demand that isn't really there. And we draw particular attention in our case to Great Western and Metropolitan Railway, which was the valuation of a connecting railway and where the assessment committee, who stood in for the tribunal in those days, had assumed another competitor who in the real world didn't exist. And Plymouth Argyle, the only potential tenant for Plymouth Argyle football ground was Plymouth Argyle. Then you have to value each hereditament individually, ladies' hosiery, and the hypothetical tenant reflects reality in that he embodies whatever was actually the demand for the hereditament. Not the demand for something else, but for the hereditament. Although this case took an unusual turn in the joint position paper, on any interpretation of that paper, I say 3 propositions are unavoidable. First, the parties agreed that the evidence showed, in reality, the total absence of demand to occupy at more than a nominal rent. 2, the tribunal ordered a rent well in excess of the nominal figure. And 3, as the tribunal's figure is clearly not supportable by the demand in the world, the tribunal has assumed demand that did not in reality exist. To do so runs contrary to the tenor of all those cases which I've rushed through, which seek to avoid distortion of the demand picture, and is directly counter to the proposition that the tenant reflects reality by embodying whatever was actually the demand for the hereditament at the relevant time. The hypothesis does not require the making of that counterfactual assumption, and given the parties' agreement in the JPP, there is no room to claim that the evidence indicated demand to occupy at £370,000. You only get to that figure by applying a counterfactual assumption. And we say that the Court of Appeal's decision, particularly paragraph 41, is no more than the application of established principles to these peculiar circumstances. Trespassed, but is that an convenient moment?
Yes, certainly. Court will adjourn.
2 o'clock.